Yes, Mr. Hughes.
Yes. Could I begin just by answering Law Justice Nugee's question about the difference between classical imputation and partial imputation systems? It is summarised by the judge in paragraph 8 of the judgment. Perhaps I could just deal with it very briefly. A classical system, which is the system the UK had before 1973, simply involves the dividends being taxed to income tax, I think in those days, with no credit at all for any underlying tax that might have been paid by the company. Simply, so that's a classical system. There is no imputation of any credit in relation to the tax the company has paid. An imputation system is one where there is a credit given for generally essentially for the tax that the company has paid. So the idea being the tax is paid, the company has paid tax on its profits. When they're then distributed, you get tax, but there is some kind of credit for the tax that's already been paid on the underlying profits. A partial, what the UK has or had was a partial imputation system. So if you, an individual received a dividend from a company, you'd be aware you would get a credit which would cover generally in the past the basic or the lower rate of tax on the dividend, and then you'd end up paying higher rate tax on the dividend, and there was no credit to cover that. You may remember that from the past. That's a partial imputation system because it didn't impute all of the corporation tax that was paid. It imputed the amount of, essentially the amount of the rate of ACT was what it was, although that wasn't formally, I think. So the companies would pay ACT on the dividend, and that amount would be imputed to the shareholder when they received the dividend. And in the past, when the periods we're talking about, of course, if you didn't pay any tax because you didn't have any other income or something, you could recover the credit from the revenue in cash. And if you were exempt as a charity or a pension fund or something, you could recover it as well.
So the ACT was equivalent to the basic rate of tax?
It was, yes. I think in the periods we're talking about, it would mirror essentially the basic rate of income tax. So that's what you would get, and so that's a partial imputation system. A full imputation system would be you would get imputed all of the corporation tax that the company paid, which is a higher rate than the ACT rate. So it might be 30% when the ACT rate was 20 or 25.
Thank you.
And as regards foreign dividends, they did operate an imputation system in the sense that you would get credit for the underlying tax paid by the foreign company, out of which the profits were paid under double tax treaties or
credit.
And that's why the European Court talks about applying an imputation system to foreign dividends and an exemption system to domestic dividends. It says that's okay as long as you give equivalent treatment, and that's what, of course, the case was about.
Thank you.
What I'd now like to cover is the short, I hope, but important point. What is the mistake of law at the heart of these claims? And I say that because if you read the skeletons on behalf of the test claimants, you might be forgiven for thinking that the answer to that question is really quite a complicated one. We submit it's actually very simple. And it is answered by the way that Mr. Justice Henderson put it in High Court 1, which is in the first volume of Authorities, tab 9, and it's at page 216. And if you perhaps just want to read paragraphs 261 and 262 on page 216.
Can you just give me that reference again? It's
Sorry,
216 of the Authorities one.
It's an Authorities Bundle 1.
216.
Page 216, yes, tab 9.
Thanks.
So it's 262, a mistake about the lawfulness of the ACT regime of the case 5 charge. He then goes on to consider the question as to how you decide what can be recovered under a mistake of law and what kind of test you apply for that, but that's not relevant to this.
It's a bit broad brush, isn't it? I mean, why isn't it a bit more? Why should it not be a bit more precise? Which is a mistake that the domestic regime for ACT here, or the case 5 charge, is compatible with EU law.
Yes. Well, I think that was what.
Maybe what
That's
Mr.
what he was
Justice
saying. The
Henderson
lawfulness of
meant.
charge. I think he meant under EU law.
Yeah.
Did he? And which bit of the ACT regime? I mean, all of it. What does he mean? The ATC, as he defined ACT regime?
I think yes. I think he has.
I mean, it's not. It's unlawful in one specific respect.
Or a number of respects, but yes.
Well, a number of respects, but I mean, it's not the whole. I mean, has all of the regime, whatever the regime is, gone, or is it just a bit of it that contravened the freedom of establishment or freedom of the capital?
It's the bit that is, it's the lawfulness under EC law of the ACT regime.
Whatever he means by the ACT regime.
Yes, but it's not that the ACT regime in its whole was unlawful, because that's not EU law.
No, it depends what he means by ACT regime.
Oh right, yes. No, I think he does.
Did the judge in the court below define the mistake of law? Did Mr. Justice Richards define the mistake of law?
Yes, I think he, yeah. Sorry, before we get to that, I was just going to show you, because it is, I think it's important, that this is in line with how the case was pleaded by the claimants originally. Well, in fact, all through.
I mean, he identifies at least in part at paragraph 39, Mr. Justice Henderson. The first main question I have to decide arises from the decision of the ECJ on the issue whether the charge to tax under case 5 of Schedule D is compatible with community law. I mean, that's a little bit more precise.
Yes.
Yes. And it is the whole case 5. The mistake is in relation to the case 5 charge, because that's foreign.
Yeah.
That's a charge on foreign dividends, obviously in relation to EU dividends only.
What's the third country dividends?
Yeah. And yes, I'm not sure whether he defines the ACT regime. He certainly sets it out. Paragraphs 64 going forward to in paragraph 14, he sets out how ACT works. I think, my lord, the point that's being made, the point that's made in the pleadings, is that the mistake is not in detail as to how the charge was unlawful.
Right.
In detail, for instance, whether there was a restriction, whether there was a justification, etc. That's not the approach that he was taking. And that we would say is also the approach, not the approach you should take in determining whether you can discover the mistake. You don't say, well, you haven't discovered the mistake because you didn't know.
It's the fact that the charge is unlawful, not the precise detail as to how it came about.
Sorry, my lady.
The fact that the charge was unlawful, so there's a mistaken assumption that the charge is lawful, and they're unaware of the fact that it is contrary to EU law, but you don't need to descend into particulars or details as to the precise respects in which it's incompatible.
Yes.
And it's the charge which is unlawful, not the payment.
Yes.
Well, one flows from the other, I presume.
Yeah, I mean, the payment is made under the mistaken belief that you're legally obliged to pay.
Yes.
Because you have been subjected to a charge to tax which is unlawful under EU law.
Yes.
Or is a system which is contrary to EU law.
Yeah.
But that's the mistake. I think the point that is being made is that it's not necessary to anticipate that in fact only part of the charge would be held to be unlawful, for instance, in the end, because of the way that the European Court decided the case in 2012.
If only the part of the charge was unlawful, you would not have been under a mistake when you paid the rest.
And so you couldn't recover that.
Yeah.
You couldn't recover the amount that you paid, which wasn't unlawful.
Yeah.
But what I'm saying is that you, to say the charge was unlawful, the mistake is the lawfulness of the charge, is not saying that you have to be mistaken in relation to the entire charge being unlawful. It could be lawful to some degree, and that's all you need. For instance, if you were told in 2000 that the ACT charge was unlawful, and you were told that it was all unlawful, it then transpires 20 years later that actually only a part of it was unlawful. You would still have discovered your mistake, we would say.
Well, because the whole embraces the part.
At the beginning, you wouldn't have discovered your mistake later when different arguments emerged and the European Court said something different. I think that's the only point we're making about this. That it's enough that you are alerted to the fact that there is unlawfulness in relation to the charge to ACT or to D5 tax. And indeed, the claimants brought a claim on that basis. You can see if you look at the pleadings, which is the claim that they're still pursuing to this day, obviously. The precise details of it have changed because of the way that the courts have decided things over the years, but the basic claim is still the same. That the charge, that there was unlawfulness about the charge. They paid amounts of tax that they shouldn't have paid by mistake. That's the basis of their case. And that's how it's separated in the particulars of claim. If I can just show you briefly the BAT particulars. They're not very long, so they're in the joint core bundle at tab 18. Page 228, it begins. And paragraph 1 is setting out a brief summary of the facts about the group. And the schedule provides a list of subsidiaries, you can see, non-exhaustive. And then paragraphs 2, 3, and 4 are a description of the system of dividend taxation, including ACT. And indeed 5 is a conclusion from that as to what would happen. And 6 is also part of the description of the ACT system, as is 7 about carrying forward ACT. 8 is simply pleading the dividends that were paid. And the particulars of those. And then 9 is the beginning of the claim. Had the subsidiaries as well as their parents been UK residents rather than residents of other states referred to above, then the dividends referred to in paragraph 8.1 would have attracted tax credits under section 231, would have amounted to direct investment income. In those circumstances, neither the ultimate parent nor the intermediate parent would have been obliged to pay or would have paid a proportionate amount of the ACT referred to in paragraph 8.5 above. That was the point that I was explaining at the beginning today. And then paragraph 10 is making the point that because the group had a lot of foreign income, which had double tax relief credits, there wasn't very much corporation tax in the UK for them to set the ACT against. So it became a permanent charge, if you like, because you'll be aware, my lady, my lords, that ACT is set against mainstream corporation tax, if there is any. And that's why it's regarded in some respects as an advance payment of corporation tax. But the structural problem that these kind of groups had was that they didn't have very much UK corporation tax. And so they ended up with a lot of surplus ACT that they couldn't set off. And then paragraph 11 says if the ultimate parent or the intermediate parents chosen to invest in a UK business rather than business carried on in the relevant countries through the subsidiaries, it would have been possible to offset the ACT on the dividends so that it would not have become surplus and therefore an effective absolute permanent tax, and that they could have surrendered it. So this is the comparator, a UK group, a UK dividend, where they could have set off against ACT.
Well, it's all encapsulated in paragraph 14, which itemises each of the areas of differences in treatment, discriminatory treatment.
Exactly.
And paragraph 15 pleads the various treaty provisions which are said to have been breached.
Yes. And 16 says they should have been in the same position as we are set off as a UK company. So the ACT provisions and dividend provisions are a disincentive to establish subsidiaries in other member states, etc. And then there's an alternative claim based on the parent subsidiary directive, which we don't have to look at. Then there's an alternative claim based on double tax treaties, which goes on for a number of pages. And then there's an alternative claim based on the Human Rights Act, paragraph 20. And then we get to the restitution. By reason of those matters, they're entitled to restitution for money paid pursuant to mistake or unlawful demands, etc. And then there's also a claim in relation, I think, to for damages under a sufficiently serious breach of this factor team claim. So my point is it's a very simple structure to the pleadings, simply making the comparison that I mentioned before between the UK and the foreign dividends and saying that there's discriminatory treatment.
Do they actually identify what they say the mistake is?
I'm not sure that they actually do in this pleading. I think they just say, it's implicit, the mistake was that they didn't know that it was unlawful, I assume. But I don't think so. I think they just say, pursuant to a mistake of law or unlawful demands.
Thank you.
But it's prefaced by the reason the matters pleaded above. So I guess you can deduce from them that what the mistake was. Because they did plead that they did actually pay the tax for the ACT. I'm sorry. The point I'm drawing from this is that it wasn't necessary to discover anything more complicated than this in order to plead their case. Now, it may well be later on the arguments became more sophisticated and complicated as the litigation developed. and there certainly were a lot of arguments, particularly about how you apply the European Court decision by way of conforming interpretation to the UK provisions. That was a major issue that had to be resolved, but none of that is relevant, we would submit, to what we're looking at today.
I mean, I'm just looking at the we've got some amended version of this particular sort of claim.
Yeah.
Why is there any reason why we don't look at those? Do we get any better clue?
Well, you don't. The reason that we would submit you don't need to look at those is because you're looking at if you can identify a mistake on the basis of which they were able to plead their case, then it's not necessarily go any further than that, because they didn't require to plead what they plead in the amended pleadings in order to plead their case in the first place.
No, I understand the point. That
Many of those are.
I understand the point is that they have. You can certainly say that by that stage they have pleaded that they made payments pursuant to a mistake.
Yes. And they've identified
that I get. It's just if we're trying to identify for us with some precision what the mistake is that the pleading may not particularly well have expressed. Do we have there's a better iteration, and it may not be the same thing. It seems to be the same thing, but I can't quite follow it. But it looks like the one at page 347 of the core, tab 25. It's in the next volume.
At that stage, they specifically identify. I suppose what was implicit in the earlier pleadings that.
Yeah, I'm just saying.
Yes.
I mean, that's. I'm not sure I can follow the pleading through, but this is the same claim, isn't it?
Yes.
Yes, it's the 80.
I mean, I'm not sure.
Yeah, it's the same claim. It's.
Is that right?
These are their 17th amended. Yes.
Yeah, it looks like it. We've missed out the intervening 15. We've missed out the intervening 15 iterations.
Yes, there are quite a lot of it. Yes.
Apart from that, 15A sort of seems to be pretty clear.
Yeah.
Yes. I think from memory, and I have to check this, that the history was that there was quite a major amendment after the decision of the first decision of the European Court, and before certain proceedings in domestic courts. I think maybe actually it's at the second stage of litigation there's a major because I can just what happened was the first stage of litigation, the Mr. Justice Henderson's decision that I showed you, really consisted of a whole series of legal argument, legal debates, legal issues. And you look at it, there are about 20 odd legal issues that have to be determined in the light of this decision. And these were determined as very much as legal issues. The second time it went back to Mr. Justice Henderson, we were actually trying the BAT claim in detail. So looking at the actual dividends that were paid by BAT, what actually happened. And before that trial, I remember that there was quite a detailed, a new pleading was put in, or an amendment to the pleading, because at that stage we needed to know precisely what BAT were pleading to deal with it.
But by I don't know why this makes much difference, to be honest, but by 2007, that paragraph 15A was in existence by December 2007, because you pleaded to it in the defence, which is at page 287.
Yes, yeah.
I'm not sure, just for me, I understand your point is they had enough to plead mistake by the first iteration, but if we want clear expression of what the mistake was,
absolutely.
It's probably that paragraph 15A, which does appear to have made an appearance quite early in the piece.
Yes, and it may have just have been thought that there wasn't any express pleading of the mistake, and that was being rectified by.
But you were pleading to it and denying the mistake had been made.
Yes.
In 2007 in your pleading in 2007.
Yes.
Because you just pleaded at page 272 of the bundle, it's not admitted the claimants made the mistakes of law pleaded in paragraph 15A or any mistakes of law.
Yes.
So I assume you'd had that 15A in some earlier iteration.
Absolutely. And that would be historically between the first reference coming back and the first hearing before Mr. Justice Henderson, which I think was in 2008.
Right.
So that would make sense that they would be pleading at that stage. Because there was an issue about, as you can see from Mr. Justice Henderson's judgment, there was an issue at that stage as to what could be claimed by way of restitution. How far that went, where was the line between restitution and damages claims, and there was quite a big issue about that at the time. So I think that's probably why this was there. Yeah. No, what I was going to, move on to was just briefly to talk about sufficiently serious breach, because that is a point that is sometimes raised. At an earlier stage in the litigation, you can see Mr. Justice Henderson's first decision. The question at that stage was, had there been what is called a sufficiently serious breach? Or, putting it another way, had the UK manifestly and gravely disregarded the limits of its discretion, as I think it is put in the case law, in order to found a claim, a fact-obtained claim in damages in this litigation. So that was the issue. And in a sense, there was a mirror of the present case where the revenue was saying we didn't have any reason to investigate this situation. We didn't have any reason to think that there was a breach of EU law, and the claimants were saying, yes, you did, it was obvious, etc. But the point I made, I think, before the judge, I think the judge records it, is the test that you're looking at is very different under sufficiently serious breach and what we're looking at under the limitation question. And that is explained, I think, by the judge in his judgment. But the reason is that the bar in sufficiently serious breach is an extremely high one to show that the government had manifestly and gravely disregarded the limits of the discretion. You have to show that it was pretty clear that the provisions were contrary to EU law. And you can see what Mr. Justice Henderson said about that later on in this judgment.
I'm wondering why that's relevant to anything that we have to decide.
Well, I don't think it is, my lady. I'm quite agreeing with you.
We've got enough on our plate in the next couple of days without chasing hares. With respect,
totally in agreement. But I thought I'd just make the point that if someone is going to say, well, there was a different approach taken by the parties in the past, I think that's perfectly explicable by the fact that these were different tests that were being applied. Can I then go on to the question, look at chronologically the various authorities and other materials that were before the judge and the evidence on those. And I wanted to start, I'm going to start with Avra Fiscal because I think everyone recognises that's an important case as a starting point. It's in Authorities Bundle 3, tab 40. Yes, 40.
That's my bundle 5 for some reason.
Ah, sorry.
yes,
That's right. We've probably all got them done differently.
it might well be. Yes, it's.
I'm afraid
5.
I always try to insist on having mine double-sided, which I think means I have less bundles than everyone else.
That's probably why. Anyway.
At tab 39, we seem to have the opinion of the Advocate General, which is also reproduced in the report. Is there any reason for
Yes,
that?
I don't. No, I'm not. There is none as far as I'm concerned.
Oh yes, there is. Right.
Can I just tell you what this case is about? You may have picked this up already. France granted a tax credit known as avoir fiscal to the recipient of dividends, and it was set against their liability to French income tax on the dividend. But it was only available to persons who had their habitual residence or registered office in France, unless it was extended to some foreign residents under double tax agreements that France had. The credit was not available, though, to foreign companies who had simply established agencies or branches in France. Now, this is a commission infringement proceedings. The commission considered that these provisions infringed Article 52, freedom of establishment, and it initiated proceedings as far back as 29th July 1981, it seems, by letter. But the judgment of the court was in fact delivered on the 28th of January 1986. And a number of quite important principles were established in this case. Can I then take you to page 1804? At the bottom of page 1804, you see the beginning of the application of Article 52 of the EEC Treaty. And then you have the arguments of the Commission and of France. And in paragraph 13, you have the conclusion of the court. It must be stated, firstly, that Article 52 embodies one of the fundamental principles of the community, has been directly applicable in the Member States since the end of the transitional period. By virtue of that provision, freedom of establishment for nationals of one Member State in the territory of another includes the right to take up and pursue self-employed persons and take up and manage undertakings, etc. This is they're setting out the article. Article 52 is intended to ensure that all nationals of Member States who establish themselves in another Member State, even if that establishment is only secondary, for the purpose of pursuing activities there as self-employed persons, receive the same treatment as nationals of that state, and it prohibits as a restriction on freedom of establishment any discrimination on grounds of nationality resulting from the legislation of the Member State. So that is the application of freedom of establishment, as I said this morning, to inward investment. And then it sets out a number of further submissions by the parties. And in paragraph 18, it must first be emphasised in that regard that freedom of establishment, which Article 52 grants to nationals of another Member State, and which entails their right to take up and pursue activities as self-employed persons under the conditions laid down for its own nationals by the law of the country where such establishment is effected, includes the right of companies or firms formed in accordance with the law of a Member State and having their registered office, central administration or principal piece of business within the community to pursue their activities in the Member State concerned through a branch or agency. With regard to companies, it should be noted in this context that it is their registered office in the above mentioned sense that serves as the connecting factor with the legal system of a particular state, like nationality in the case of natural persons. So the treaty talks about nationality, but the court is saying, well, in regard to companies, that is equivalent to the registered office. Acceptance of the proposition that the Member State in which a company seeks to establish itself may freely apply to it a different treatment, solely by reason of the fact that its registered office is situated in another Member State, would thus deprive that provision of all meaning, that provision being freedom of establishment. Even if the possibility cannot altogether be excluded, that a distinction based on the location of the registered office of a company or the place of residence of a natural person may under certain conditions be justified under such as tax law, it must be observed that in this case the French tax law does not distinguish, for the purpose of determining the income tax liable to corporation tax, between companies having their registered office in France and branches and agencies in France, situated in France. By virtue of section 209, both are liable to taxation on profits made in undertakings carried on in France, to the exclusion of profits which are made abroad, or which France is entitled to tax under the terms of a double tax agreement. Since the rules at issue place companies' registered office in France and branches and agencies situated in France on the same footing for the purpose of taxing their profits, those rules cannot, without giving rise to discrimination, treat them differently in regard to the grant of an advantage related to taxation, such as shareholders' tax credits, by treating the two forms of establishment the same way for the purpose of taxing their profits. And the French legislature admitted there's no objective difference between their positions with regard to detailed rules relating to taxation. And then they set out a number of other arguments that the French government made. And in paragraph 24, it must first be noted that the fact that the laws of the member states on corporation tax have not been harmonised cannot justify the difference of treatment in this case. Although it's true that in the absence of such harmonisation, a company's tax position depends on a national law applied to it, Article 52, which is our freedom of establishment at that time, prohibits the member state from laying down in the laws conditions for the pursuit of activities by persons exercising the right of establishment, which differ from those laid down for its own nationals. And then they deal with an argument about tax evasion, which they say cannot be relied upon in this context. And then paragraph 26, finally, the French government is wrong to contend that the difference of treatment in question is due to the double taxation agreements. Those agreements do not deal with the cases here at issue as defined above. Moreover, the rights conferred by Article 52 of the treaty are unconditional, and a member state cannot make respect for them subject to the contents of an agreement concluded with another member state. In particular, that article does not permit those rights to be made subject to a condition of reciprocity imposed for the purpose of obtaining corresponding advantages in other member states. And then the conclusion from that in paragraph 27 is that the discrimination that they've identified constitutes a restriction on the right of establishment of insurance companies, and therefore it was a breach of the treaty in paragraph 28. So what that case makes clear is that, first of all, I think as everyone agrees, the fact that tax has not been harmonised and it's a competence of member states does not mean that EU law does not apply to tax provisions, and we'll see that stated a number of times thereafter. And also, the rights conferred with the treaty are unconditional and cannot be made subject to the contents of an agreement, a double tax agreement. So that was avoir fiscal, and just for your notes, the witnesses, the experts dealt with avoir fiscal in their reports. Mr. Gamy dealt with it at paragraphs 34, 68 and 103. And Professor Barnard dealt with it at paragraphs 76, 145 and 168, following the number of paragraphs after that. Now, as I mentioned, what avoir fiscal was about was inward investment, and it made clear that it would be a breach of freedom of establishment to restrict establishment by a non-resident company in the state in question. The opposite situation was dealt with in Daily Mail, which is in Authorities tab 41, page 1810. This is a case from the UK. The law was at that time a UK resident company required Treasury consent in order to cease to be UK resident. And in fact, it was a criminal offence to cease to be resident without Treasury consent. the applicant sought a declaration that it was not required to obtain consent in ceasing to be resident in the UK in order to take up residence in the Netherlands. The UK court made a reference to the ECJ, and the judgment was delivered on the 27th September 1988. And the important point from this judgment is on page 1823, 1824. Paragraph 16. Even though those provisions, the provisions being the provisions on freedom of establishment, are directed mainly to ensuring that foreign nationals and companies are treated in the host member state in the same way as nationals of that state, they also prohibit the member state of origin from hindering the establishment in another member state of one of its nationals or of a company incorporated under its legislation, which comes within the definition contained in Article 58. As the Commission rightly observed, the rights guaranteed by Article 52 would be rendered meaningless if the member state of origin could prohibit the undertakings from leaving in order to establish themselves in another territory, another member state. In regard to natural persons, the right to leave their territory for that purpose is expressly provided by the directive, which is the subject of the second question. Now, the decision which the court in fact made in this case was that simply changing your residence did not amount to exercising freedom of establishment, because it was the same company. It wasn't establishing itself, so the court said, in the other state, and therefore the company failed in its claim that preventing them from changing residence was contrary to Article 52. And you can see that paragraph 23 and 24 of the decision. So that was the reason for the result in the case, but the important point is it was recognised that freedom of establishment would be engaged by situations where what they call the host state restricted the establishment of a company resident in that, established in that state, establishing themselves in another member state. And again, the experts dealt with that, and they recognised that that was what it said in Mr. Gammy's report in paragraph 69, and in Professor Barnard's report, paragraphs 238 to 245. So that's 1988, and then in chronological order we have the Rudding report, which much is often made of.
When you're running through this chronology and referring us to the reports, are you at some point going to identify when your expert said the penny should have dropped? Or is it implicit that it was dropped at all? I mean, has the penny dropped yet or not?
I think Professor Barnard's view was that after avoir fiscal, it should have been possible to discover a mistake, because that showed you that discrimination, that tax was within it, and that kind of discrimination could be. But certainly after, I think she said certainly after Daily Mail, which made it clear that outward investment was. At that point, she thought it could be, if not before then. But that was. But that's.
That's
I think to be fair,
it can't be her view of what a lawyer in the UK would have advised, because she wasn't a lawyer in the UK and couldn't give that evidence.
If I could just explain exactly that. That's not the evidence she was giving. She wasn't giving evidence as to what lawyers were advising at the time.
Or could have advised, or should have advised.
Well, I'm not sure that really either of the experts should have been giving evidence strictly about any of these questions, because these are the questions, I think as Mr. Gammy says, really rightly, for the court to determine.
Well, apart from the fact the Supreme Court seems
So
to
you
have
need an expert.
said, no, you'll need to know what a well-advised well-advised multinational corporation, etc. So as I put to you before lunch, built into the concept of well-advised is what would people have advised at the time, isn't it?
Yes, but I don't think they were, well, I would submit that they weren't suggesting by suggesting expert evidence, that the expert evidence should be on what they would have advised, or indeed what other people would have advised.
Because
At the time, divorce from the law, which was there. I mean,
so are you saying this wasn't a question of fact for the judge, and that in fact it was something else? And if
I
so,
am
what?
saying that was my, well, it's a question for the judge, but it's not a question that would be answered by asking somebody what would have been, what you would have said in 1996, 1993. That's not the way that.
Well, obviously, because the you in that case might be a maverick, and and the you might be out on a limb. But if you're looking at expert advice at all, it's got to relate to any consensus as to what the profession as a whole would have, having regard to the developments in the law, would have thought.
I think it's, well, Lady, I think it's a bit more subtle than they might be a maverick or out on a limb. I mean, different advisors, and we all know that, can take different views, not being mavericks, but simply because they, within
all lawyers
a
have different views
framework,
about the rights and wrongs of an argument of the case, but the real question is, would, in the light of the prevailing opinion and the way that the law was, the way that the wind was blowing in the law, would somebody who was approached for advice say, there is a viable argument here, there's an argument that's got legs, rather than one that will be laughed out of court, to use the vernacular?
yes, was a bit more than would. Could someone? Of course, the test is could. You just
No, the test is, could they have, with reasonable diligence, have discovered it? But they have to have discovered something which is viable.
Oh yes, but views on whether something is viable, well, it depends if you like what you mean by viable, of course, and we'll come back to words. But views on that kind of thing could vary between perfectly respectable non-maverick
That's what
advisors.
makes this test so difficult.
Well, I don't think it does. Well, yeah, I agree. I'm not disagreeing with that. But I think to make it workable, one does have to, in practice, leave it to the court to decide objectively what was it possible to discover that mistake at the particular time. Not to ask lots of different advisors who probably have retired by now what they think they would have said, or indeed what someone else might have said.
But that obviously has a bearing on what it was possible to discover.
Well, with
And the
respect,
Supreme Court seemed to think that too.
I would, with respect, disagree that that's what the Supreme Court thought.
Well, then what did they mean by you're going to be able to ask an expert? Why did they refer to
Well, the
expert evidence at all?
The experts, I assume, I agree that's very difficult because, I mean, the evidence that we're looking at here is not, in a sense, expert evidence at all. I mean, in a sense, it's factual evidence as to what would have happened, what people were thinking at the time in the past. Given that this is a very unusual circumstance, but normally you would expect you would be looking at what was being said by professionals or academics or both at the time, and you could perhaps make an assessment from that, because you could look at titles saying this, these editors are saying that, etc., etc. And I quite understand that, and that may well be what the Supreme Court had in mind, but we're not doing that in this case. The evidence is quite clear in this case that there was no one, there are no articles except for one, which I was going to show you, which even touch on the question. And the evidence is entirely what somebody says they remember, or they think they remember, having happened in the past when there were no discussions about it. And this is the odd thing about the whole case. Mr. Gammie's evidence was nobody thought about this, there were no discussions about it. etc.
Yeah, so he's being asked to postulate a hypothetical that a client suddenly pops up and says, what do you think about the possibility that I might have made a mistake in paying all this tax?
Well,
Which nobody actually did at the time.
Well, the problem is that he actually says he's not doing that. In fact, he says through his evidence that he is distinctly not advising, not giving evidence on what he would have advised at the time, because he regards that as not being what he's asked.
No.
If he had been giving evidence on that...
What would the reasonable hypothetical legal advisor have done in those circumstances?
Yes, but with great respect, that's not a question that someone can answer on the basis of evidence. I mean, sorry, it's not a question that Mr. Gammy is in any better position to answer than anyone else who can look at what the materials were available at the time.
Well, he does have the advantage of being somebody who was an expert tax advisor at the time, and so at least he would be able to shed some light on what he and other expert tax advisors might think of the argument, surely.
Yes.
Because you've got to postulate that the client, who is the person to whom this knowledge is being attributed, is going to ask an expert, have I made a mistake or not? Or is there a possibility that I've made a mistake?
And the question is, well, if we're going down that line, which is hypothecating a consultation happening in 1996 or whatever with the expert, you then have to consider the question, well, what standard would you expect the expert to be advising to at that stage? Well, exactly, my lord, yes.
So, I mean, I'm just struggling to fit your submission with what the Supreme Court said at paragraph 211 in Appeal 2, we looked at page 799. My question is, have we reached the time, do you say, when, quotes, a well-advised multinational group based in the UK would have had good grounds for supposing that it had a valid claim to recover ACT levied contrary to EU law?
Yes.
You say yes.
And
is that on the basis of the evidence concerning the state of understanding of the law within the relevant categories of professional advisors during the relevant period? Because it seems to me your submission seeks to bypass that whole inquiry completely.
I don't think I wouldn't say that. I don't think I do try to bypass it. What I'm trying to do is say that you can't simply say to a professional advisor, what would you have said in the past, and therefore and substitute that in for.
No, I'm not suggesting that you necessarily would just pick out somebody, you know, at random on the spectrum and say, well, what would you have said if? But I think the evidence that the Supreme Court envisaged would be given would be evidence about the state of understanding of the law within the relevant categories of professional advisors during the period.
Yeah.
In other words, it's somebody saying, well, you know,
that raises the question.
Relevant categories of professional advisors (brackets) who are capable of giving competent advice or well advising their clients, either could have said or would have said, probably could have said X.
No, that in the context of a case like this, where the evidence was that the professional advisors were not considering the point at all at the time, the question then arises, how do you apply that to a case where there's no thought? So Mr. Gammy, nobody could give evidence to say this is what people were thinking about this point.
Because they didn't think about it.
Because they weren't thinking about it. Now, at one stage in the cross-examination, which I might show you, Mr. Gammy, I put this to Mr. Gammy, and he said, well, does that mean, in fact, the answer is that there was no legal thinking at the time on this point? To which my answer is probably yes, there wasn't any legal thinking on the particular point. Now, of course, there would have been...
So what's the answer to the proposition that if there was no state of understanding of the law within the relevant categories of professional advisors, that a, quote, well-advised multinational group wouldn't have had good grounds for supposing it had a valid claim because it wouldn't have been so advised?
But it has to be, you have to assume that it's seeking advice.
All right.
But in deciding what that advice is, one of the factors you might take into account, I quite agree, is what were people saying about it? What were people advising even perhaps at the time?
I think
You might, but if you're in a situation where nobody was advising on it, then the court then has to decide for itself, or could they have discovered it based on what was available, which was obviously the case law of the European Court.
well, that's sort of second guessing what the professional body of opinion would have been. And
Well, I think that's inevitable in this situation.
well, if it's inevitable, it's surprising the Supreme Court said what it did. I mean, it seems to me that if they didn't turn their minds to it, as my lord says, then you ask yourself, hypothetically, what would have happened if a client turned up on the doorstep and said to this hypothetical reasonable advisor, what do you think? Have I potentially paid all this tax under a mistake? The hypothetical advisor might say, well, never turned my mind to that. And as far as I'm aware, nobody else thinks that you would have done. So as far as I'm concerned, that argument doesn't have legs. I mean, that's one way of looking at it. The other way is to say, oh, let me go off and do some research, which is what sort of takes it into your territory.
Well, I would strongly submit that the second of these must be right, because the court, in its deciding this, must look at the situation. Remember, the court doesn't have to decide whether an advisor would have said you've got a good case or you will win.
No,
All the court has to decide
it's arguable.
is whether it's arguable, and you can determine that by looking to see is there anything in the case law, is there anything in the principles that it's not arguable. Is there any case against this? Is there any
virtually
case that
anything's
would cast
arguable.
doubt on this proposition?
Pretty well anything's arguable in the light of hindsight, and
No, I
the
don't.
judge was being very, very careful to factor out hindsight, of course. So you've got to look at the state of the law as it then was, and say,
Yeah.
if your hypothetical legal, well-advising hypothetical legal advisor had gone off and done his homework or her homework, would they have come back and said, I think there's an argument here? Is that what it really boils down to?
You would, yes. Is it arguable, or is there something that we can identify?
So given that there's no consensus, and given that nobody's actually applied their minds to it, then the question is,
But that's not,
if somebody was asked the question directly and went off and did their homework, they would have come back and said, I think you've got a runnable case.
exactly, and that's exactly how things work in real life.
So, I mean, I think as I understand your submission, you basically say the entire UK tax industry is asleep at the wheel. Nobody, despite, there's no shortage of people looking for the next sort of wheeze manoeuvre tax saving device in the tax industry, in my limited experience of the tax industry. But they're all actually asleep. But if only somebody had asked them, they, of course, would have then said, oh, of course, there's a case here.
What a great idea.
Well,
let's
that's
see if we can claim all this money back.
Well, that's, with respect, that's exactly what happened, and the question to Gabby about that's exactly what happened with Hirsch, because he accepted that Hirsch could have made their claims years before. There was nothing. The position was exactly the same. It just happened that they came along in 1995. They could have come along years earlier and done it. It's not that they're asleep at the wheel. It's just that nobody thought about it.
Well,
It's just not unusual.
Well,
People just don't think about things, or don't
But
have
it's
reason to think about them.
yeah, but it's curious in an industry which is,
Well,
full of people who are looking for a tax. If I say device, it gives the wrong impression. A tax saving or a tax.
yes, but
The next tax scheme to save to attract people to
Means of minimising
use
But
their
there are, I mean, so you're right, that is the case. The question is, well, why did it happen at that time? Now, we don't know that because, and it's not criticism and you can't, draw any conclusions from this, but we don't know because of privilege what actually happened, why these advisors who did advise people to bring the claims in 2002, why they did it then. But there are a number of reasons why that could be the case. In particular, two things came together at about that time, just before that. One of them was Clement Benson was decided, and then DMG was being decided. So if you don't have mistake of law claims, then these claims are much less attractive, because they can only go back 6 years. They're not really terribly, not so attractive. But if you can make a mistake of law claim, then you can go back to 1973 with interest, etc. So that was one. The second one was the group litigation orders came into force in 2000. And,
So
and
we're
they make it much
postulating
more
that
attractive.
long before Kleinwort-Benson is decided, somebody comes up with the idea that they might have made a mistake of law and it would give them a viable claim. At a time when there wasn't even a runnable argument that there was a mistake of law.
But these group litigation orders all came about after 2000.
When was Woolwich decided? Because that's rather earlier, isn't it?
1992.
92.
But that would only give you 6 years.
Yes, but it still enables you to say, if I've paid tax that I can now say I shouldn't have paid, I can get it back.
Well, you could make a claim, and indeed Hirsch did make claims in 1995. I'm not sure if they made it on mistake of law as well, hoping that would happen. But they did make claims. But well, Justice Snowden was asking me, well, why, when all these people have an incentive to do this, why did it happen then rather than 5 years earlier? And we don't know, and we can't know why that actually happened. We don't know at what stage these advisors came up with this idea or thought of it. We've just no idea. But what you can see is there are other reasons why everything came together around that time. And indeed, Dr. Whitehead in his cross-examination accepted that the existence of the GLOs were very helpful in respect of this, because it does mean 20 groups, for instance, can get together and share the cost of taking this litigation. Whereas one...
Who was Dr. Whitehead?
Dr. Whitehead he's been involved, I think probably since the beginning of this, in he's a solicitor, at GHA now. He's been involved in managing these for 20 years. And he gave evidence the trial.
You see, that's what makes it so difficult, this sort of hypothesis. The hypothesis is that pre-1996, at a time when nobody at that stage supposed that there was a claim for restitution for mistake of law, because the law in the country suggested that there wasn't, somebody would have actually gone and asked this hypothetical well-advised advisor, if I run a case on a restitution for a mistake of law, has it got legs?
Yes.
Because my hypothetical claim for restitution on the basis of mistake of law will depend upon the UK tax position being incompatible with EU law.
Yes.
And what I find quite odd about all of this is that it's the premise that anybody would have asked that question is fairly far-fetched.
Yes.
Because they've got to have got a crystal ball and assumed that at some point the House of Lords was going to change the law in relation to mistake of law. Yes,
but that is clearly stated to be part of the test by the Supreme Court. I mean,
yes.
And they specifically make this point about Clement Benson.
Yes.
The question is not when could you discover that you had a worthwhile claim in the sense of the claim that you were going to make to recover money. It's when you would have a worthwhile claim in relation only to the mistake element, because that's what you've got to discover. But it isn't that odd, because...
But can you have a worthwhile claim that you've made a mistake in circumstances where that wouldn't give right to any claim in law at all? That's what bothers me.
Yeah, your advisor would say, well, you might have made a mistake of law because it's all contrary to EU law, but don't think you can you can't get the money back. It's just tough.
You could have made a claim. Certainly after 1992.
You could have made a Woolwich claim.
You could have made a Woolwich claim, but but Woolwich is not based on mistake of law.
No, but it would be based on the unlawfulness.
It's still based on the proposition that you've paid tax that you
that
weren't legally obliged to pay.
Yes, because it was unlawfully charged.
Yes. So it's based on the same proposition that the UK tax regime is contrary to.
And indeed, that's exactly the position Hirsch took advice in 1994, well before Clement Benson. Made claims in 1995, well before Clement Benson.
Right.
So it's not fanciful that people would do that.
So the combination of Clement Benson and DMG magnifies the value of the claim.
Absolutely, yes.
But it doesn't. It's not the first time you can bring a claim to say I paid.
No.
You made me pay tax and I shouldn't have done.
No. All I'm saying is that commercially,
Yes.
it makes a big difference. And then my Lord Justice Snowden, I think, was asking me, well, why would these people who had a great incentive to be discovering, putting these things to their clients, why weren't they doing it before? And we don't know. And I'm not suggesting we do know, but there is a very good explanation, one explanation. So you can't draw the conclusion that just because they didn't do anything till 2001, 2002, that they couldn't, or they didn't, in fact, even discover it before then. We simply don't know when
So it's enough on your
these
case
people
that as a
thought of
comment-
this. There are two particular people that, again, Dr. Whitehead mentioned in his evidence, who one I think was in Pricewaterhouse and one was in KPMG or something, who came across this possibly at the same time, sort of, who are the driving forces behind this. But we don't know anything beyond that. We don't know how it came about, which obviously would be relevant if we didn't know. It would be very relevant evidence as to what the position was, because we might be able to see, well, what was it that you based your decision on and when? So it would answer a lot of these questions, but we don't have that, and there's nothing we can do about that. That's not something that we can take into account, because it's all privileged information. But that's one of the other problems with this mistake of law. It always runs into privilege, because what you'd really like to see is what advice were people giving in the 1990s. But again, we're not going to be able to get that, because those who gave it, well, first of all, it's confidential and privileged, and they wouldn't be able to tell you.
Well, they might have to waive privilege in order to get over the burden of proof, mightn't they, given that it's the claimant's burden and not the defendant's.
But I'm not talking about the claimants, I'm talking about people giving advice to other clients in the 1990s. You could well have had people who had given advice and could come along in theory and say, yes, I consider this point, I gave advice to this client. They didn't take the case forward, but that's what I said. But none of that is going to be available. I mean, that is one of the problems. All you're going to have are the publicly available information as what people published. And of course, the very point Lord Justice Snowden makes about commercial confidentiality is one of the reasons why people will not be publishing things very often. If you have a really good idea about making a claim, the last thing you're going to do is write an article about it. Because that would just, everyone will know about it then. So
Why is that such a bad thing?
it's a problem because you wouldn't necessarily have people who had thought about this, let's say at some point, writing articles about it.
Well, why is it a problem?
No,
if you have a very clever idea as to why the UK tax system is incompatible with EU law, why is it a problem making that publicly known?
Oh, because you want to take it to your clients, and exactly what happened in this case. Get them all together and launch claims. You don't want other people to.
Why not? It's a
Why
good
not?
idea.
Well,
It's a good idea.
It's all to do with money, I think. The economic way that they would operate.
I mean, I can see an argument that you don't want to tip off the taxman in case there's some way that they can block it. But they can't do very much about the fact that it's incompatible with EU law. So that's not going to be.
No, it's not. It's not the taxman. It's other professionals who take the idea and exploit it themselves. All I'm saying is that there's a lack of evidence.
Well, unless they're going to pinch your clients.
Well, I don't think that's unlikely.
No. I can see you don't want to tip off the opposition so that they steal a march on you and pinch your clients first and get their custom.
Anyway, the simple point I'm making is we don't know about any of this.
No.
And in fact, you're not going to know. All you're going to
But
have...
I can't see any difficulty with an academic coming up with a wizard wheeze and putting it out
No.
on the,
I quite agree.
on the
And
platform.
if there were articles and books which dealt with the point, and had been discussed it, then that would be very relevant, I agree. If someone was saying at the time, this is a good claim, or saying this is a bad claim because we don't think the EU law applies in this situation because the companies aren't comparable or whatever, then obviously that would be a relevant thing to take into account.
Right, so Forget the commerciality.
Because that was what the advisors would take into account at the time.
So forget the commerciality of actually bringing proceedings or venturing money.
Yeah.
You say that we've currently seen enough in the two cases, Avoir Fiscal and Daily Mail.
No, I haven't finished yet, but I mean...
No, but,
okay.
but you're saying, at this stage, anybody who had gone to his lawyer and said, look, I know it won't make any commercial sense, but can you just tell me, have I overpaid tax based on these two cases? You'd say a good lawyer, a good tax advisor, a good tax lawyer would say,
EU lawyer.
right, would say, yes,
Well,
you have.
Possibly.
possibly.
Would say possibly.
Possibly.
Yes.
Possibly.
They don't-
You've got to. Yeah, it's a good argument. I mean,
Yes.
there might be quite a number of reasons why you can't, in practice, do anything about it.
Yes,
Because it won't commercially be sensible for you to do anything about it. But
well, that's irrelevant.
you say the only question that needs to be answered, possibly, that's an argument that's got something about it.
Exactly.
Is just simply, have you been overcharged? Have you effectively? Have you been overcharged? Have you paid tax
I shouldn't have paid.
that you shouldn't have paid?
Exactly, because that's the mistake.
That's the mistake. And you'd say, on the basis of what we've currently seen, Avoir Fiscal, Daily Mail, the answer should have been.
And it would put, I mean, there is one more case, which is Commerzbank, which we haven't quite got to yet. And what that makes...
But I'm just trying to pin, and was there any evidence to suggest that question, did you ask that question to either of the two, or whether was that question asked to the
Well, I think
experts?
Professor Barnard gave that evidence. Mr. Gammy wasn't prepared to say at what point he would have said that there was a claim at all. Or, sorry, Professor...
But if
Mr.
you're
Gammy
asking us to
I
criticise...
did ask him about when he would have done that. And
If you're asking us to criticise Mr Justice Richards for not having reached the conclusion you've just suggested would have been the correct conclusion,
Yeah.
I'd certainly want to be fair to the judge. Was that put to either of the two witnesses he heard, and an answer given that would have supported that conclusion by the judge?
Well, certainly Professor Barnard gave evidence that was, I think before then, I think after Avoir Fiscal, even possibly even before that. Mr. Gammy said that he didn't regard it as part of his role to say what he would have advised.
Can I at least...
I did ask, he was asked, sorry.
It may be
I'm
just
not
for
sure.
me, because others may already have read, and I don't
Yes.
know, read in detail Mr Gammy's report and, your expert's report, and I can't remember the
Professor
names.
Barnard.
Professor Barnard and may have it committed. I don't have it committed to memory, so do you want to show me where she said that?
In her report, yeah. Yes.
Because you're going to have to say, aren't you, that the judge should have accepted this evidence rather than the evidence he did accept?
No, I'm saying that the judge should have, I'm saying primarily the judge should have made up his own mind about this.
The judge shouldn't have bothered with either of the experts because
He doesn't need
what
an
they actually
expert
had to say didn't really matter.
He didn't need an expert to decide this.
That I think
Because
is
he can-
HMRC's case on the basis that whatever the Supreme Court had to say about it, it's not a matter for expert evidence.
Well, the Supreme Court did not say you
my
had
lady
to...
has put to you rather bluntly
I think they
the
did
point
say,
that I think I was
evidence-
working out.
Sorry, but sometimes one has to call a spade a spade. And
They
I
did say
think that's
evidence
really
may
what it
well
matters.
include expert evidence. They didn't say it was necessary.
And you just say nonsense,
And I say,
respectfully, nonsense.
well, no, because I would say in other contexts, because of course they were talking generally, not about this case alone. In other cases of mistake of law, it may be very
Yeah, but I think
useful to have an expert.
I think to be fair, they've committed a fair few words to pages. They might have had this particular scenario fairly to the
I don't think
forefront of
that's
their
correct.
mind.
Well, I would doubt that because remember they are making a decision that will apply to all mistakes of law.
No, but they were remitting this case for this.
Yes.
Specifically to this judge. Yeah.
Yes, but in paragraph 2 and 11, where they deal with this, they were talking generally about how to deal with these cases. They weren't specifically
But
saying.
in 211 they say C255, and in 255, at least I think I remember them, so they said in 211, I think they said C255, and
Yes.
in 255 where they specifically dealt with what would have to happen in this case, isn't it?
Yes,
Didn't they say that?
Yes, I think they did.
and
In 211 they said, blah de blah de blah. Oh, this point is considered in greater detail in para 255 below.
Yes.
And in 255, that was where they said, okay, so we can't determine it ourselves, so it's going to have to go back to the judge.
Yes.
And
If it was just a question of examining the cases, why couldn't the Supreme Court do it themselves?
Well, first of all, they didn't have all. I mean, we were arguing about the principle. They didn't have all these cases. We hadn't made submissions about any of that.
But they have said in principle they couldn't do it themselves and it would have to go back to the High Court. So
Yes, well,
the question is still a valid one.
And at what,
you mean they could have said, well, we'll have another hearing and you can produce all the cases and documents,
Yeah,
and
we'll
we'll
decide
assess
it
it
here
all.
and now, and that will save them
Yes.
having to go back.
and if you look at 178, which is where they talk about evidence, I think, evidence from practitioners, the question they pose is, it's possible to investigate how legal thinking on a particular question developed over time.
Yes, but that's
And
in
that-
the context
that
of what they
does-
said in 178.
That does look as if what you're doing is looking for evidence as to what people who were around at the time
Yes.
thought.
But the evidence would be, as they say in 178. Well, if you have to read the whole of
You've got
178.
to read it all, but it's
Developments and judicial thinking don't take place in a vacuum. So they're talking about the things which would affect judicial thinking, first of all.
yes,
Which are judgments
practitioners,
and whatever.
universities, legal journals.
Yes.
So
And then they go on to say that would also influence, obviously, claimants and their advisors because they would
Yes.
be looking at the same things. But none of these things are somebody coming along, nobody's going to come along to a court and say, the law ought to be X because I think it is X. And,
No,
and,
but
the
they-
judi-
but-
and there's a consensus of opinion in the country that it is X.
but why
That's not...
why is this not inviting what Mr. Gemi did, which is to investigate how legal thinking on a particular question stood in 1996? Because that's, as I understand it, that's what his evidence was.
Well,
that in 1996...
I would say with respect that it wasn't what his evidence was. It wasn't what legal thinking on this point was because his evidence was nobody thought about this. Everybody, I assumed this, and everybody I think else, well, everybody I knew assumed that these claims would fail, and that continued. And this is something I'm going to come to when I look at the evidence probably
So there's a
tomorrow.
difference between thinking
That
a claim
continued until 2005.
There's a difference between thinking a claim will fail and thinking it doesn't have legs, or...
Oh yes, there's a big difference. Yes, his view was the claims would fail, which perfectly respectable view to take, but wrong. But that's not saying the claims are hopeless or whatever. That's not what he was. That's not the evidence he was giving. In fact, at some point in his evidence, I'll show you tomorrow, he said what he was basically saying was the position was uncertain. Throughout this period, the position was uncertain because there was no case on dividends, which was relevant. All the cases were on something else. So there's no case on dividends, the position was uncertain. He then says at one point, what uncertainty means is a matter for the court. If the position is uncertain, is that a worthwhile claim or not? He didn't know. He obviously wasn't deciding what the standard was. But the thrust of his evidence was the position was unclear because there wasn't a case, and it remained so until 2005 when Marks and Spencer's was finally decided, and at that stage it was clear that the claimants would succeed in their case. So that was the thrust of his evidence. So he wasn't saying, well, in 1990 people thought this about this kind of claim, and then a case came along and they thought something different about this kind of claim. That wasn't the evidence he was giving. If he was giving that evidence, you could see that that would be relevant kind of evidence. You can see people were thinking about it, people were, discussing this claim. We had all sorts of evidence about other claims, as you'll have seen.
Is there any particular
none of that.
reason? I'm just following up my Lord Justice Snowden's position. I've just been looking at Professor Barnard's report,
Yeah.
and when one gets to the absolutely critical part of her report at page 237 of the supplementary bundle. We get to paragraph 485, 486, 488, and then there's a gap.
The full report is in, I'm sorry, my lady, the full report is in the additional documents bundle.
Well,
Which you
why is it not in the supplementary bundle? I mean,
I think the position was because of the page restrictions, it seemed to have been decided to produce.
well, there may
Parts
be
of
a huge amount of stuff that's in the supplementary bundle that, because of the page restrictions, shouldn't be there anyway. And I would have, speaking for myself, since we're arguing the toss about these two expert reports, would have thought it was an absolute imperative that we have the full copies of both
Yeah.
experts' reports in a bundle that is one of the official bundles before the court. Sorry to be
Yes.
grouchy about it, Mr. Hewitt, but it's
I-
not terribly satisfactory.
I agree. I totally agree with you.
So we have to look at Professor Barnwell's report somewhere other than in the supplementary bundle.
It's in. You should have some three what are called additional documents.
Yes, I know, and there's an application before us for permission to go outside the normal page limits.
Yeah.
Oh, is it not in the unagreed additional document?
Yes, sorry, it's called
Yeah,
unagreed
somewhere.
additional.
It's in the
It-
white files.
Yes, well, yours were white.
Mine are all white.
Yeah. Oh, there's a black one as well.
All right. Okay.
Yes.
I should say
In
the
fact,
bundles-
they are
I should say the
agreed.
bundles are very nice to work with. I mean, they
Yeah.
haven't fallen apart. They're nicely put together. You can manoeuvre your way around. I'm
Good.
not saying anything about the content. Whoever's done the bundling, whoever's done the bundling, you know,
I'm glad to hear that.
praise where praise is due.
Right.
So it begins on page 186 of that. It's tab 8 in volume 1.
Right.
And tab 7 is Mr. Gannon's report.
Yes. Right. Okay.
Which paragraph?
493, isn't it? 299, page 493. And then she goes on at 494 and say, well, if you're wrong, I'm wrong about that, you can go for a later date. And at 495, if I'm wrong about that, you can get to it in 1995.
Yeah. Yes, this is the summary of. I think that appears in a more detailed.
Right. Now she says that she talks about it in terms of a challenge to the UK tax rules. Does she mean? What does she mean, challenge? Does she mean you?
Under EU law, she means the challenge to the D5 and the
So,
ACT provision.
so at this stage, with avoir fiscal in 1986, you'd have been told if you went to a lawyer, this is your, so your contention is, if you'd have gone following avoir fiscal and said, have I overpaid UK tax because the charge was contrary to EU law, you say the answer would be, somebody would say, yeah, you might well have done. That's a good argument.
That's
You would also, though, have been told
depends what you mean by
presumably.
good.
Pardon?
Depends what you mean by good.
Well, okay,
Argument.
it's just
It's viable.
sufficiently viable for your purposes.
Yes.
Um,
But I
and the problem you're saying that existed at the time was that Woolwich hadn't been decided then. So could you have got it back? Could you have claimed it back?
in 1986, if you had, you mean, or
Which was decided in 92, so...
Yeah. So I mean, what would somebody have told you? They'd have said, yes, you've paid under a mistake, but you can't get it back. Is that right?
well, of course, it would have had other consequences. I mean, you could have recovered certainly the corporation tax under the statutory provisions for recovery.
And is that good enough to start limitation running for other purposes of a claim?
Well, again, we're not looking. I mean, I think as the Supreme Court made clear, What we're looking at is when you can discover the mistake, not
Yes,
when you can
that's
discover.
but that's what I'm saying. Sorry, I'm just still trying to understand why, you said, it's not significant that there wasn't any evidence at this stage as to what people. The Supreme Court seemed to envisage that you could answer the question that they said should be posed by asking what was the state of legal understanding at the time. When I put that to you, you said, well, actually, we don't know why there wasn't lots of discussion about this. It could have been people, were talking about
Yes,
it, but there were other reasons why, absence of GLOs,
indolence.
whatever, that you say why it might have been that people weren't overtly giving this sort of advice, or even thinking about it, because people might thought, well, it's a very academic point, but where does it take us? I'm just trying to understand.
Exactly.
I'm trying to understand the sort of factors at play, and I thought one of them might be that people weren't asking because they didn't think it would lead anywhere or any consequence to ask the question.
Well, that's
Is that what you're saying, I think?
Well, that's one possibility. I'm not suggesting there's only one reason. I mean, there's lots of reasons why people either don't think about something, or even if they do happen to think about it, don't go to the trouble of writing an article.
Of course,
about
but I'm just trying to. Sorry, I'm just trying to.
There's lots of reasons for that.
I'm trying to identify a few of them.
These are. There's plenty. I'm not trying to establish something on evidence that this is why it didn't happen. I'm just saying that these are the explanations. So there's nothing unusual in the fact that nobody was writing about it or nobody was thinking about it. I mean, generally lawyers only think about things that they're being paid to. One would assume. Certainly only think about it in a focused way. My simple point is that it's perfectly understandable that there wouldn't be any discussion about something or thought about it. On the other hand, there might have been. I mean, some things just so happens that people are interested in. I think we'll see that the most favoured nation argument, I think it was regarded as quite a sexy argument. And so people did discuss that quite a lot.
But you see, all these sorts of arguments, I think we have to. The question is whether or not this particular mistake could have been discovered. And so I don't think one can simply say it would have been open to somebody if they went off and said, have I paid too much tax in general? The good lawyer would say, well, there's lots of respectable arguments in all sorts of fields that bits of UK tax legislation are incompatible with EU law, which seems to me to be, with respect to Professor Barnard, the sort of hair that she's setting running. One's got to focus a little bit more on whether or not it can be said, I have paid advanced corporation tax or haven't been able to get back the advantages under the treaty because of a discrimination. Is it arguable that I've paid money which I shouldn't have done because under EU law there is an argument on discrimination?
Yes, and that, sorry my lady, that with respect to, is precisely the question that you are assumed to have been asking.
Yeah.
The Supreme Court are not saying that you would be generally wondering whether you made any mistakes in your life, but whether you made this particular mistake.
Yes.
So the question is, if you went to a lawyer and asked them about these payments of ACT and D5 tax, and look how unfair it is, I'm paying these, but UK companies don't pay them, and everybody was aware of this. We know.
So speaking entirely for
Then
myself, I can't see exactly what relevance it has for there to be a learned discussion, extremely learned discussion, about direct taxation or any other sort of taxation that relates to individuals, as opposed to this particular line of tax.
Well, I would agree that a case about individuals could only be relevant, a European court decision could only be relevant if it espouses some principle that would be generally applicable. So, for instance, if it espouses the principle that direct tax is a matter that can be, you can breach the treaty in relation to direct tax, which I think there was some doubt about going back decades. because it is regarded as a competence of the
Yes.
state. But if the court says yes, that is the case, Article 52 applies if you discriminate, despite the fact it's direct tax, that would obviously be relevant because that would be telling you something.
It would be a start.
Exactly.
It wouldn't be the finish.
No, but we have that. But what we also have are, as I was showing you, the cases which say outward investment is something that's a target of freedom of establishment. So if you're a UK company and there are provisions which restrict your ability to establish in another member state, that's something that freedom of establishment deals with. There's also, I haven't come quite to it yet, but Commerzbank, which makes a simple point, which is that residence, discriminating on the grounds of residence, is an indirect discrimination on the grounds of nationality. Because the treaty talks about nationality, you will see. But it was established in Commerzbank that if you discriminate on the grounds of a company on the grounds of residence, then that is an indirect discrimination on the grounds of nationality.
I mean, it's interesting.
So these are fundamental points, but they've all been established well before 1996.
Yeah, well, I mean, Professor Barnard's conclusion is that actually a well-advised multinational could have discovered the relevant mistake from the point in time that the UK entered the EU in 1973.
Yes, because there were cases before then which dealt with tax, direct tax. In fact, I think.
So why didn't the take up my Lord's question? I mean, why didn't the Supreme Court just say this?
Well, because none of this was argued before the Supreme Court. They didn't know what.
It's not as if they,
Straightforward point.
it's not as if they didn't have the cases in front of them.
Well, they didn't. No, they didn't. They didn't have any of the cases that we've been looking at.
No, my problem is a slightly different one, which is
Because before then, of course, the question that had been asked in the Court of Appeal and the High Court before were in this DMG, which was looking at the final decisions. Which of these final decisions is the right one?
Yes, and they said it's not right to look at it through that
And they
lens
said
anyway.
no, and so there was no argument about any of this in the Supreme Court. It's quite important to understand that. We weren't arguing about the answer to the question. We were arguing about whether
what the question was.
whether DMG should
What was the
overrule
correct
it,
question?
essentially.
Yes.
And Clymer Benson.
No, I understand that, but my point's a slightly different one, which is that the Supreme Court decides that DMG is the wrong question. And they're clearly, when you look at paragraph 178, contemplating that in a case like this, this is not a case of a mistake when you make the payment in the sense that anybody would tell you that that money wasn't due. This is a case where legal thinking, the Supreme Court says, evolves over time. And it's quite clear that they regard that as a matter for evidence. Right? What the evidence was as to how the legal thinking evolved, and by reference to all the materials we've seen reference to. And my question was, if you're right, why is that a case of evidence? Why isn't it just a case of saying, we, the court, or the lower court, can look at the decisions of the ECJ over time and the wording of the treaty and so on, and decide for ourselves when this had become a viable case. But that's not what they do. So why don't they do that? Why do they say go and
Because
ask?
these are not the only things that you would take into account. You would take into account what, if there was such evidence, what has been written about it at the time. So how the case was perceived at the time. Because that can change. I mean, especially in European law, cases which were seen in one way in the past might be reinterpreted or seen.
What's wrong with Mr. Gemmy's opinion then, which says,
Well,
I was
Mr.
there at the time, and I can tell you that nobody thought that this was a run-up. We thought there were far too many obstacles.
That's this is the problem. You can say nobody thought about it, but to then say that there are too many obstacles suggests that it was thought about. And that's the problem. To conclude that there are too many obstacles in the way, you have to think about it. I mean, obviously, you can't do that without considering it. What the evidence was that nobody thought about it. Now, it might be said that's because they assumed, without thinking about it, that They may have had a thought in their mind that, you know, international tax, that's not a thing that that's European law has anything to do with. But our submission is that you cannot decide the case on the basis of that kind of assumption. If you're going to say, well, we're looking at these advisors, they were there at the time, they hadn't thought about this, they may have had an assumption it didn't apply. You then have to ask, well, if they were asked about the point, because that tests it, if they were asked by a client, what would they have done? Well, in my submission, what they clearly would have done would be to actually look at the case law of the European Court as it was at the time and advise the client. They wouldn't say, no competent lawyer would say, well, you've come along to ask me if you can investigate bringing a multi-million pound claim, or any claim, it doesn't matter. They're going to say, no, don't bother, because I haven't thought about it. Everyone assumes that.
Is it possible? Well, the question would have been, please, Mr. Advisor, tell me, or Miss Advisor, have I got a runnable argument or a viable argument that I can take to the authorities to say that I shouldn't have paid this tax because the English provisions under which I paid this tax are incompatible with EU law?
Exactly, yes.
That's the question, isn't it? So the client's got to have the nerves to think in the first place that there's a possible EU law argument, and then ask the question of the lawyer, and the lawyer then goes back and says, well, the EU court does say that there are situations in which national legislation could be held to be incompatible with EU law, but neither I nor any of my colleagues would think that this is one of them. That's really Mr. Gammy's point.
Well, I'm not sure it is, but I mean, even if assuming it was, that wouldn't be the end of the question. The question then would be, well, why say that?
Why not? Because
nobody would accept advice like that, and nobody would give it. If the advice was, the advice would have to be, look, there are these cases that have just, we've got to this stage in the cases. Tax is obviously subject to EU law. Outward investment, i.e. Forming a subsidiary, a foreign subsidiary, is something that freedom of establishment deals with. We're in a situation here where, on the face of it, the UK provisions treat foreign subsidiaries less favourably than UK subsidiaries. So that's a prima facie, looks on the face of it. What is there against this position? What Mr. Gammy says is, well, it's possible that the European Court would say that the foreign subsidiaries and the UK subsidiaries were not in a comparable position. Now, maybe it is possible, and I have to make it clear that our position is not that the position was clear in 1996, far from it. Everyone accepts the position was unclear.
That it's possible that they wouldn't have said that, and the question is that it was arguable.
Yes, exactly. There's nothing in the case law which suggests that that's what they would have said, or points to the fact that that's what they would have said. Now, his other point is, we'll come to this maybe tomorrow, but his other point is Bachmann. This is a case about fiscal cohesion, which is something, a justification that the member state could raise against this restriction. So they could say, all right, there's a restriction, but it's justifiable. The question then is, would the Bachmann decision, which, as I say, we'll come to, but was about something completely other, would that definitely apply so as to knock this claim out? And in my submission, the answer clearly would be, no, it doesn't. It might apply, but it might not. And there's nothing in the case law up to 1996 which points to the fact that it would apply. And I'll need to show you these cases just to make that good. In fact, possibly, it may be where we want to go now, which is Bachmann, because I think we've roughly reached that point. I just want to mention in passing that at about just before this time, that was when the Mr. Verkuyen was challenging the tax assessments in Holland. So just for your note as to where we are. So can we look at Bachman?
When was
Because this
he,
is quite
when
important.
did he first start his claim in terms of the chronology?
Well, I'm not sure we know exactly when this was. It was tax assessments for 1991.
Okay.
He challenged them. It doesn't seem to appear anywhere where exactly he challenged them. But the appeal decision, when it went to court in Holland, was in 1996.
Yeah.
So one presumes it was 1992, 1983, somewhere around then. But we don't have the date in any of the as to when he precisely challenged it. But one assumes a 1991 assessment would come in sort of 1992. So then we have Bachman, and that's in tab authorities tab 43. So Mr. Bachman was a German national who was employed in Belgium. So this is what's called a frontier, some kind of frontier case. In relation to Belgian tax, he was denied deduction from his total income for 1973 to 1976 of contributions paid in Germany pursuant to sickness and invalidity insurance contracts and a life insurance contract. And the reason he was denied deduction was because under Belgian law, only voluntary sickness and invalidity contributions paid to a mutual insurance company recognised by Belgium and life insurance contributions paid in Belgium could be deducted from income. So that was the problem. And if we look at the judgment of the court, which was delivered on 28th January 1992, and it's page 1869. This was a case actually about free movement of workers. So if you look at paragraphs 8 to 11, you will see that the arguments of the Belgian government there were being dismissed.
And that was a case of indirect discrimination, wasn't it? Because it was said, well, it applies across the board, and it said by the court, well, yes, that's right.
Yes.
But normally nationals of other member states who are going to be adversely affected by
Yes,
the rule.
that's right. That's right. And then the need to preserve the cohesion of the tax system begins at paragraph 21. Essentially what was being said by the Belgian government was these insurance and mutual insurance contracts outside Belgium are not taxed when the money comes out of them in Belgium, whereas the contracts of which we give a deduction in Belgium are taxed in Belgium. That was essentially the point. And so they deal with both accepting the justification in principle, but also the next step of the argument always is proportionality. So is the measure proportionate, a proportionate way of achieving the justification? And the court holds in this case that it was. It says it's not possible, paragraph 27, it's not possible to ensure the cohesion of such a tax system by means of measures which are less restrictive as issued in the main proceeding. So the cohesion here was that an individual making payments who got a deduction would be taxed when the money came out, whereas an individual paying to foreign insurance companies, not in Belgium, would not be taxed. And this is dealt with in the reports by Mr. Gammy at paragraphs 51E and 107 to 113, and by Professor Barnard in paragraphs 309 to 315. Now, what Mr. Gammy says is that, broadly speaking, this would be a stumbling block, potential application of this justification. And we'll see, and we'll look at a few later cases how it was applied in later, but pre-1996 cases. But I would submit that on the face of it, there's no obvious connection between that decision and the kind of case that we're looking at in FII. Now, of course, it's possible. Nobody is suggesting otherwise, that the European Court could develop the case law in the future and apply a justification of this sort. But of course, they would also have to consider whether the UK provisions were proportionate to achieving that. And so it wouldn't be good enough just to have a justification on the basis of fiscal cohesion. It isn't relevant, but in fact, in FII, in the second reference, that's exactly what the European Court did do. They decided that the provision was justified by this, but not proportionate. So that's why we got to the position we got to in the end. I don't say that's relevant at all, because the question is, what would be the position perceived in 1996? So that's Bachmann, that's important. We'll have to come back to that when we look at Mr. Gammy's evidence. The next case is Commerzbank. We only have to look at one very short part of it. This is the case which established that discrimination on the grounds of residence is indirect discrimination on the grounds of nationality, or where the seat is. This is the case again from the UK, from England. What happened in this case was that Commerzbank, who were a non-resident company, became entitled to a repayment of tax due to litigation in relation to double tax treaties. And as the law stood at that time, it was only resident companies who could obtain repayment supplement, which is a form of interest, on the repayment of tax. And so Commerzbank claimed this. They were refused by the Revenue, and they argued that that was a breach of the right of establishment. And they were successful. As you can see from if you look at the head note, it was regarded as a breach of establishment because, broadly speaking, foreign companies if they establish a UK subsidiary, they would get repayment supplement. If they established a foreign subsidiary, they wouldn't get repayment supplement. So that was a restriction which wasn't justified. But the passage I was looking at is paragraph 15, which is on page 1894. if you look at paragraphs 14 and 15 together, that's making the point that the use of the criterion of fiscal residence within national territory for the purpose of granting repayment supplement on overpaid tax is liable to work more particularly to the disadvantage of companies having their seat in other member states. Indeed, it's most often those companies which are resident for tax purposes outside the territory of the member state in question. So that's that's the indirect discrimination that you identified before. I don't think Mr. Gammy deals with that case in his report, as far as I could see. Professor Barnard deals with it, paragraphs 321 to 331. And then in chronological order, we come to passages from Farmer and Lyle. And the reason I'm taking you to this is because the judge actually relied on the passage from Farmer and Lyle, remember, in the judgment. He said this demonstrates or supports the view that there was this view or consensus at the time. And so it's in the joint supplementary bundle at tab 27. It is a passage on page 269.
What date is this published?
It is in 1994, I believe. I think it's 1994. Oh, yes. Mr. Farmer tells me.
Tab 27.
If you have tabs, for some reason I don't.
Yeah.
It's page 269.
Yeah. So I don't have. What's the name of it?
It's Farmer. And what the name of what?
Prohibition of discrimination.
Yeah. Sorry, it's just there's no title page, so I'm just.
Oh, I'm sorry.
Who are the authors?
It's Farmer and Lyle.
It's the one referred to in the judgment.
Yes. And it's called EC Tax Law, I think. I was just asking Mr. Farmer if he could remember what it was called.
Yeah, no, it is EC Tax Law. I think
Yes.
it's on every other page. It says.
Yeah.
It's also on the index on page 3.
Yeah.
Yeah. So, and it's the passage, the last full paragraph, beginning. It's important to appreciate. And what they're talking about here is the decision in Apport Fiscal.
Yeah. That starts at 267 with that discussion.
Yes, that's right. And in the previous paragraph, you can see at the beginning, they say, as regards France's second group of arguments, the court made the obvious point that the absence of harmonisation did not preclude the application of Article 52. Article 52 does not permit any derogation from the fundamental principle of freedom of establishment on such ground. And then the next paragraph, it's important to appreciate that the court's decision was based on the facts that under French law, French tax law, the position of the two types of taxpayer was substantially the same. The court expressly left open the possibility that distinctions based on residence might in some cases be justified. That would, for example, probably apply to a refusal to grant tax credits on dividends paid by a resident subsidiary to its parent company resident in another member state, since the non-residence of the parent company would place it in a different tax position from a domestic parent company. Now, this is referring to what I've called the Class 4 type argument. If you remember, I described that at the beginning. The dividend income of the foreign parent would not be taxable in the member state of the subsidiary. The principle of non-discrimination on which the judgment in its commission in France is based does not oblige a member state to take account of the fact that a non-resident company may be subject to further taxation on certain income in its state of residence or elsewhere. And then it's this bit, I think, which the judge seemed to rely on. Double taxation arising from conflicts of tax jurisdiction must be resolved by convention or harmonisation. Now, what they're talking about there is this, what I call the Class 4 argument. Because if you remember, what would happen in many cases was that the tax credits were given under double tax conventions. And of course, that was a matter for agreement between the states in question. So that this was a passage which was talking about that particular argument, which was, I think, an argument that was in vogue at the time. It isn't a general point that double taxation has to be dealt with by conventions wholly. And indeed, if you turn around to page 272, you will see that they, under double tax conventions, they say, this comes from Commission in France, member states may not rely on a double taxation convention concluded with another member state in order to restrict the application of Article 52. In responding to the French government's contention and Commission in France of the different treatment of permanent establishments was attributable to double tax conventions, the court held the rights conferred by Article 52 are unconditional, and a member state cannot make respect for them subject to the contents of an agreement concluded by another member state. Particularly, that article does not permit those rights to be subject to a condition of reciprocity imposed for the purpose of obtaining corresponding advantages. So, and I put that passage to Mr. Gammy because it had been suggested, I think, in earlier cross-examination that was talking generally about double tax conventions being outside EU law. And we can see, I can just take you to the transcript, which I'm afraid again is in the unagreed manual. The full transcript. It's at tab 14 if you've got the volume 2, I'll not put mine on volume 2, which is a transcript of day 3 of the hearing. And it's page 127, which is on page 515.
Sorry, you have to state it again.
I'm sorry.
You supplemental. Are we in the same bundle?
No, it's the additional documents bundle.
This is your black. Yeah.
It's difficult to. There was a time when all the bundles were made up by one solicitors and they were all the same, but now that's not the case, I'm afraid.
Sorry, I don't think this is the bundle I've just.
It's not.
Yeah.
It's the unagreed documents bundle of 3 white.
Yes,
Right.
file 2.
File 2, right.
Should be file 2, it's the same as mine, and it's tab 14. And it begins on page 127, line 11. Well, line 11 is the page number, because that's the page in the trial bundle.
Internal at page 127.
Internal page 127, which is on page 515 of the
Yeah.
bundle. And if you just read from there down page to
Somebody
127,
supply me with a magnifying glass, I might be able to read it.
Oh, I'm sorry, is it extremely... It's 127, then 128, and then it goes over the page to first 6 or 7 lines of 129.
So what's the point? I've read to 129, line 9.
Yes.
Is that
What
it?
Mr. Gammy is saying there, confirming there is that what they're talking about in this
Why
passage.
does it matter what he's? Why does it matter what he's saying?
Well, one,
We can read it. I mean, on
you
your,
can read it yourself, but he's an expert, and his I mean, all of this is based on his word, if you like. He made it clear in his evidence that there's only one article that has anything to do with this, and this is not it. And so it seemed helpful for him to confirm that this passage was not talking about what he was talking about. That's all.
Oh, okay.
You can read it yourself, but I mean,
yeah.
again, it's useful for the expert to confirm that. So it's very odd that the judge should think that a passage from this book supports Mr. Gammy's evidence, or Mr. Gammy himself says it doesn't.
Well, he doesn't
This
say
is
it doesn't support its evidence. He says it's dealing with a particular situation.
It's dealing with a different point, yes.
Which is not the situation with which you're dealing.
Yes, but the reason the judge thought it supported it is because he thought it was talking more generally about including this situation that we are dealing with. That, as I understand it, was the judge's point in the judgment.
Right.
Because he says, well, it's said that there isn't anything to support this view, that this view existed, but this passage does, he says. And I would submit he was wrong about that. And there must be some importance in this, because this was, I think, the only thing which the judge relied on to support the position, the findings that he made, apart from Mr. Gammy's evidence. So, again, continuing on the chronological, we then come to another article, another passage for article that the judge relied on in his judgment, and it's Professor Tiley. It should be one of the documents which you were handed up, I hope. Now these are extra. This is an extra. I hope this begins on numbered page 198. Is that what you have?
197.
197.
These are said to be extracts from the All England Law Review.
Exactly, that's what they are for 1994 and then for 1995. We didn't produce the whole of it. We could have, because they were in fact in the bundle before the judge in entirety. But I thought I wouldn't bother you with it, because most of it is about something completely different. It's about law in general, obviously. But it's this passage. Oh, I see what's happening. So it's the passage on 198, beginning freedom of movement of workers.
Sorry, where on 198?
198, halfway down, there's a heading, although it's not very obvious, which is freedom of movement of workers.
No, there isn't.
Do you have that?
There's a reference to Bachmann, but there's no reference to freedom of movement.
Oh yes, I see it.
Oh, I see. Yes, it's not actually headed as a head note, is it?
It's sort of a heading.
It's sort of in the
I'm afraid this is probably an online version.
Yes, okay.
You know.
Anyway, it's the bit that deals with Bachmann and Halliburton.
Yes, and it's the bit that the judge cites. While the court was able to find a clear breach of EC law in Halliburton, they found no breach in Bachmann. The urgent need is to discover the difference. This difference may lie in the concept of the cohesion of a tax system. Tax system may provide different rules for residents and non-residents if the difference is necessary to protect the cohesion of the tax system, and that's exactly what Bachmann decided. And then he goes on to go through Bachmann. You'll see the rest of that page and the first two paragraphs of the next page, simply recording what Bachmann decided. And the judge thought that was significant. We say that all that's being said there is exactly the question that arises. Bachmann decided it on cohesion grounds. Halliburton wasn't decided on cohesion grounds. That's it. But then, if you then look at the next year's version, which is on page 200, and the European aspects begin at the bottom of page 200. And on page 201, at the top, he says, there were some working out the concept of the cohesion of the fiscal system, which was used in Bachmann to justify discriminatory provision. The 1995 cases suggest that governments will rarely invoke Bachmann successfully. And then he goes on to look at these cases, and I was going to come to those, particularly Wheelock's and Schumacher. I don't know whether
Might be more convenient to do that tomorrow.
it might be my idea.
So do you want us to read on to the rest of that particular passage overnight, maybe?
Yes, that might be until
Right up to the top of 203.
Yes, and he then moves on to something completely different now.
Right.
Ironically, one of my cases as well. I remember it well.
Are we still on track in terms of timetable, Mr. Ewart?
Yes, I think so. We've had quite a lot of discussion about this, so hopefully a lot of the points have been dealt with. So.
Good. Right. Well, we'll call a halt there and resume at 10:30 tomorrow. Thank you very much.